Hello there, welcome to the show. 2 channels here, now you know. Like and subscribe, it's all we need. Alternature or here to speak. And defense, let's take a peek. Collaborating for your eyes. Sharing content, no surprise. Together we shine brighter than one. Join our journey, it's just begun. Like and subscribe, hit that bell. Enjoy the show and wish us well.
I know it's always me.
You know I do that on purpose.
Yep. I'm ready.
Good morning. Good
Good
morning.
morning.
I've taken my silly pills. Nice.
I've just taken my delirious pills, so it's okay.
Awesome. High
Fell
five.
back asleep.
How are we all? What is it? Thursday today. Thursday.
The Stoop Sisters.
Could be worse.
Could be. Trust me, I can't.
Yeah.
Bree has a nickname for some people we know. They're called the Stupid Sisters. So at least you didn't call us that, Gabby.
All right. Well, good evening, Australia, and good morning, US. I'm the Defence Rest. This is Alternate Juror, and we are continuing on today with the conclusion to the Christopher Dunn conviction hearing. The gentleman that was convicted in 1991, wrongfully accused, apparently, with the testimony of 2 gang members who basically lied under oath on the stand, and he was convicted to life imprisonment plus 90 years and is now in the process of appealing that for his freedom in Missouri. So if you don't know anything about these cases, there is 2 videos, days 1 and 2, which will give you the full introduction and overview up to date in the playlists on both of our channels, because we are streaming together simultaneously because we are IT nerds.
Yeah.
Did my nose just grow? Some things we're really good at.
We're great at laughing. Oh, I got an echo.
Have you?
I do. I don't anymore. It's gone now.
No, it's not
Must be a
from me.
ghost again.
Oh, look, I just had an the alternate juror is live. Tune in.
Wow.
Okay, so last night you finished up with all the testimonies.
If you want to call it that. The
Oh,
state didn't
really? I didn't actually
really.
watch it.
You didn't miss anything. I literally turned my camera off because I was in a group chat with a couple people from my family, and I needed to deal with that. And I felt my head drop almost to my desk because I fell asleep. And I was like, "Oh shit! Oh, my camera's off." It was awful. They put one guy on the stand that used to work in corrections, but never had any direct contact with him. They didn't qualify him as a witness or as an expert of anything. I think that's what they were trying to do. They asked him questions. The other side was like, "Have you ever talked to him?" "No." "Did you know about him before this trial or this hearing?" "No." Hadn't heard anything about him. I don't know what the point of him was, because he just left, and then that was it. There was no more argument. I think he was the offer of proof that we kind of couldn't hear those arguments about.
Yeah, okay.
She wouldn't go to the microphone.
When you've got no evidence, you've got nothing to argue.
And then they had the original prosecutor on the stand, who became a judge, and he's now retired. He is probably the nicest grandpa in the entire world and a nice father. Had nothing to add. He's not stupid in the fact he was covering his butt. Like and he doesn't even remember. You can tell. Like he
They didn't even have either of the Michael or Damaris testify.
yeah. And it sounds like they could have had is it
Well,
Demora's
they
step?
got Michael's deposition, but that's only because Chris's wife hired a private investigator.
So I mean, they didn't do their jobs at
No,
all. And it really bothers me.
not for the entire time, not even at the end. Mm.
So we're at closings and then
Yeah,
I
yes.
unlike the last judge, this judge has been disappointing too because the judge in the Lamar Johnson trial was so engaged and he would ask the defense and their state and all the attorneys, he would ask them questions, he would ask the witnesses questions. Like he dug so deep into the details of the case and what was in front of him. Um, it was like it was really interesting to watch because he was in it. This
Mm.
judge doesn't seem to be
No,
in
you can
it.
almost hear him snoring in his
Yes.
lapel mic.
Yes. So I didn't find, unless you did, where like the other judge, when he delivered his decision, he came into court and delivered his decision.
No, this one
I think this guy just delivered it like
yeah, I couldn't find any
like through an email. You know what I mean? I don't think there was bring
he
him to court.
basically, once they finished their closings, he's like, okay, that's it for the end of the day. I've got a lot of work to do. Bye. And then
And then
I
came
couldn't
back.
find any footage on him actually rendering his verdict. So
Yeah.
I've
So that was 2 months later. There's only news
yes,
reports of it.
yes. So
But so that was disappointing too. That just kinda told me how he was just not
oh,
engaged.
I just looked at my my bad pause moment.
Yeah, well, that's kinda how I feel like he feels
Yeah,
about this
yeah.
thing.
So the closing arguments are probably going to pretty much recap and go over 99% of what we already know anyway. So I might actually put it up to 1.25. And if it's going to be repetitive, I'll just L as much.
Yeah, so each side only gets so the I keep calling state and defense, and I know it's petitioner and respondent, so,
Wow.
um, his side is going to take 20 minutes and then a rebuttal of 10, and then she's supposedly gonna take the full 30. But I really wonder how this woman sleeps at night. I really
I
do.
know. I know. I did listen to some of it and it just sounded like she was regurgitating pretty much what we've.
But this is the second time we've seen her. Like for me, this is the second time I've watched her try to keep somebody in prison,
Yeah.
and it's
Uh,
bothersome.
so I've got this particular the end of the hearing, and then I have another, I think, 5 little clips and videos to play. They're not long, but they're they run in succession as to the events that transpire after this. Okay, so stay tuned. Don't go away. There is it just doesn't end like that. It's not all rainbows and butterflies, as Judge Fleischer would say.
It is not.
Not
There's no
at
little bunnies hopping
all.
in the woods.
No, there is no little buddies hopping in the woods. So
It
pop that bubble of illusion. Let's get into it, shall we?
it's kinda disgusting.
Yes, it is.
Sure.
Now, let me know if you can hear it.
Well, I hear him breathing, so
Oh,
he's alive.
please. 30.
Okay.
I think he needs a new
we'll go back
chair.
on the record.
It's
So we're
electric.
going to be doing closing arguments now, and each side is
Watched
afforded
him
30
zoom in.
minutes. So Judge Shaw is going to go first for 20 minutes, I think you said. And then, is that correct? Oh, Mr. Gore, I apologize. Mr. Gore will go for 20 minutes, and then Ms. Eastep will have her full 30, and then Mr. Gore will have 10 minutes for rebuttal. And I'll ask that no one gets up and leaves or moves about or anything while they're arguing. In between each arguer, if you need to leave, that we'll be okay. But just stay put where you are while they are arguing. Okay, Mr. Gore. Yes, sir. Okay, we're going to be fairly informal about that, and I'll give you guys as much time as you need, actually, as long as we're not here till 8 o'clock to say what you want to say.
Nothing
Okay.
like that, Your Honor.
Okay, you may proceed.
May it please the court, counsel. Judge, 34 years ago, almost to the day, Mr. Dunn was convicted based on the alleged eyewitness testimony of 2 children. It was a eyewitness identification that was made under circumstances that made it highly probable that there was a risk of misidentification. It was nighttime. The ID occurred in the midst of the children running for their lives. And the shooting was conducted by someone who clearly had designs on not being identified and had staged the entire murder to happen that way.
Yay!
What this hearing has been about is
I wonder if it's a little quiet.
Of the original.
Rest it some more because it's up to 250. Let's go higher.
Because it's a little quiet for me, so that I'm wondering if it's a little. Make sure my earbuds are in now.
All right, we're at 500.
Original case. What our purpose here
That's
today is to show by clear and convincing evidence that there remains no credible evidence to support Mr. Dunn's conviction. And I think it's undisputed, and it's always been undisputed, that the only evidence supporting Mr. Dunn's conviction was the testimony of 14-year-old Michael Stepp and 14-year-old Damaris Stepp and 12-year-old Michael Davis.
Can you hear it?
And they have since recanted that testimony. And Your Honor, to be clear, our motion that we filed and you've reviewed, nowhere in that motion do we ever attack the investigation, the manner of the investigation, or the manner of the prosecution. Our motion is premised on the fact that the testimony that supports the conviction is no longer credible and cannot support a conviction. And we've presented in the last 2 days ample evidence to show that. We take a look at Damaris Stepp. He has recanted on multiple times, which is why we have to date his recantations. 2018. But there is no dispute, is there, that you lied at Mr. Dunn's trial? Is that right? Correct. Michael Davis. We have the 2015 affidavit recantation. I couldn't see. It was too dark to see anything that night on a lot. We have the Michael Davis 2015 recantation in his interview, which was played here for the court. So I went under oath and I lied. I said he did it. I'd never seen him do it. You know what I'm saying? And we listened to that testimony played audibly. And I submit to Your Honor that his manner, and the manner in which he presented that testimony in that interview was extremely credible in terms of his recantation of his testimony. He said that his testimony was fabricated. And he explained that he was simply
Good morning, Adele.
Of the older, only by 2 years, but the
Morning,
older
Adele.
Stepp, who was the first one
Good to see you.
to falsely identify Christopher Dunn as the assailant who committed the murder of Rico Rogers. Now, we have the recantations, so the question becomes, are those recantations credible? And we submit to you that they are. If we look at the very outset, those taped interviews, right from the very outset.
If you're doubting the credibility of the recantations, you should have doubted the credibility of the testimony at the very start.
I mean, they were young.
Mm.
That already hurts them. Not saying that somebody that young cannot accurately recounts a traumatic event, but it's hard for anybody at any age to do so. And they weren't living the best lifestyle. So, it's like, were they just not going to tell the truth right off the bat? I'm not.
I mean, what have they got to gain though by doing so? Nothing.
Right. Right.
So why would they bother otherwise?
Yeah. There was a lot of factors in that, in their lives, unfortunately, that affected their decision, I think. And youth being the huge one.
Yeah. Maybe a little bit of stupidity.
Well, young and
The
dumb.
two children were expressing uncertainty as to their identifications. The more step. You see somebody, but you don't see them. I thought my mind was playing games. That's the very first night. Expressions of uncertainty. Their testimony from that very first night was inconsistent. DeMaurice Stepp originally says that he believed he saw the assailant come from the west side of 5609, and he subsequently changed that to he saw the assailant come from between the gangway, which is between 5607 and 5609. And we see here that in the original question, Detective Stenham misstated it as the 5700 block rather than the 5600 block. But right away,
the other thing I heard about this too was apparently I was watching. It was one interview that he was doing with someone, that Christopher Dunn. He never read his Miranda rights ever.
Ooh.
Yeah,
Surprised I didn't bring that up. But they probably
Yeah.
don't have video to prove it one way or another.
yeah. How's that? Just another.
inconsistencies began.
Just horrible.
Here we have him
Horrible.
at slide 8 saying that the assailant was hiding around the corner.
Yeah.
Which is very inconsistent because he's saying he's hiding, so how can he identify him?
Yeah.
Then at trial, we have DeMaurice Stepp testifying that he saw the assailant about 3 minutes before he ever fired,
Why
but
didn't
didn't
you
react, chose not to react. And that's a statement that doesn't arise until trial, when he places it in the gangway. And interestingly, DeMaurice Stepp is the only witness out of all the statements that have been made that places the assailant, the murderer, in the gangway between 5607 and 5609. Here he is in 2005, and Kathy began. It was too dark. I couldn't see anything at night. We go to slide 11. Here he is in an interview with the Attorney General's office, an interview that they put forward as a recantation of the recantation. But even in that interview, he's recanting his original testimony. I didn't actually see Dunn with the gun. That it wasn't Dunn who pulled the trigger that night. We go to slide 12. The 2018 habeas hearing testimony. Did you see the person firing the shots? No. So was that because it was dark? It was dark. Now, the interesting thing about the May 2018 testimony is that, let me see if I can get this straight. It's a recantation of the recantation of the recantation, right? So he's back and he's saying, all those things I said, they said that I said when I rejected the recantation, I never said those things. More from 2018. So that would have been a lie, isn't that right? Yes, it would have been. Now, what other corroboration do we have of the recantations other than the improbability of the identification to begin with under the circumstances that we understand existed in terms of lighting, in terms of the fear and trauma that the children were experiencing? We've got corroboration from Curtis Stewart. And this is back in 1991. Curtis Stewart, who was confined with DeMaurice Stepp, which DeMaurice Stepp has acknowledged, yes, I was confined with Curtis Stewart, overheard him saying that he didn't really know who had killed Rico, and that all he cared about was that he was getting a deal. That's Curtis Stewart overhearing that in 1991. He did an affidavit in 1994, and he testified in 2018 at the habeas hearing. Then, of course, we have the ruling by Judge Hickel, where Judge Hickel simply rejects DeMorris Stepp's testimony in total. He's a completely unreliable witness. I just reject out of hand everything he says. And that's our position, Your Honor. You look at DeMorris Stepp, and he has obliterated himself as a witness. His testimony, whatever he says about this matter, should no longer exist. But I would also submit to you that if you're going to make an analysis of which of his statements are most credible, looking at the surrounding evidence, the recantation is his most credible position he's taken. But we don't at all object to Judge Hickel's position, which is his testimony should not be considered at all. What is the other corroboration of the credibility of the recantations? You have the fact that at the very outset, there's this inexplicable inconsistency between the children. One saw him wearing tiny sunglasses, which, as
At night.
Dr. Franklin pointed out, was really the sole basis for him identifying Christopher Dunn. He identified him based on his statements in that statement by the sunglasses. And then you have the older child, DeMorris Stepp, seeing no sunglasses, saying nothing about sunglasses, and identifying him as wearing a blue cap. Now, the sunglass testimony is improbable because we notice it occurred at 12 o'clock midnight. 12 o'clock midnight. And you're trying to shoot somebody from I think the closest anybody places the shooter is 12 to 15 feet, and you're wearing sunglasses. Makes no sense. And that was at the outset. Now, the fact of the matter proceeded to trial, and 12 jurors here in the city of St. Louis found beyond a reasonable doubt that the testimony was credible and they convicted Mr. Dunn. That happened. But those jurors did not have the information that's
That
before us
song's in
today
my head
of
too.
these multiple credible recantations of that testimony. We've heard Davis provide all of the reasons why he testified the way he did. We heard his very credible interview statements regarding that. And are those that 2015 recantation, is it credible? Well, it is, because if you go back and you look at the very early testimony, you see that in his taped interview, he says, how long did you know Christopher Dunn? I knew him for about a month.
Just
There's a
so
whole
80s.
story. There's a whole story
So have you seen
behind that.
him anytime prior to this incident happening? Yes. Knew him for about a month. At trial, he testifies. And do you know Christopher Dunn? Yes, sir. How do you know him as a friend? Right away, you've got the inconsistencies. And you'll recall in Mr. Davis's 2015 interview, he's surprised when they tell him, you described him as a friend. He goes, really? Are you sure? Take a look. He goes, I'm not sure I ever would have described him as a friend. Now, if we go to slide 19,
That's how dedicated we are, Adair.
testimony from the 2015 interview.
Yeah,
And this
something
to
like
me is
that.
just a very credible statement about what he did.
It ain't for
So
the money.
I went under oath and I lied. I said he did it. I never seen him do it. You know what I'm saying? The shot was like a sniper. We never seen the shooter. And it's interesting because that term sniper comes up a couple times, because you'll recall that's also how Eugene Wilson described it. Eugene Wilson even had a theory that somebody might have been shooting from an apartment window. It was dark and nobody could tell where the shots were coming from other than west.
So early, even the crack of dawn's not
And
safe.
if we look at slide 20,
Good morning,
Morning,
Regina.
this provides very credible
Thirsty Thursday. All right.
explanation about why he made the statements and why he recounted all those years later. He said that as an adult, he grew to realize that you can't just say that, what I'm saying, somebody did something and you didn't know, and you take their whole life away.
Mhm.
You know what I'm saying? Because it is hell in prison. You know what I'm saying? That's a very credible explanation of a grown man realizing the impact of something that he did as a child. So, Your Honor, Stepp and Davis are proven liars. That places us in the same place the judge found himself in the Amrine v. Roper case, where the judge said, in these peculiar circumstances, the state should get no benefit of the original judgment because it is based solely on the testimony of liars. Eugene Wilson, an extremely credible witness who came in and gave what I consider to be the most credible eyewitness testimony about what it looked like out there.
Oh, but was there a
He
light
also
in the
used the
pole?
term sniper. It was like a sniper. We couldn't see
You
where the
know,
shooting
there
was
was a
coming
freaking
from.
light pole.
He places himself about 15 feet from the porch. And
Light
the
pole.
interesting thing about
Listen.
Eugene Wilson is he also takes us inside the minds of that 12 and that 14-year-old and explains to us why they would do something like they did. First of all, they're 12 or 14, 12 and 14, so who knows why they're doing what they did. But he says, you know, they considered themselves bloods. More likely, as Detective Stidham explained, the perpetrators. But they considered themselves bloods. And Mr. Dunn came around that evening visiting with his good friend, Eugene Wilson, and happened to have
Was there a
club
globe in it?
that was blue. And so they considered him a crip. Or there was a discussion that he was a crip. And Mr. Wilson speculates that that's why they identified him falsely. And he was there for the whole thing. And Your Honor, if you look at the evidence that's been submitted by the Attorney General during this hearing, what they are essentially doing is inviting this court to adopt the same reasoning as that 14 and that 12-year-old. We're bloods. Rico Rogers was wearing a red hat. Christopher Dunn was here a few hours ago wearing a blue hat. My friend is dead. Somebody needs to be held responsible. Mr. Dunn's a crip. Let's say it's him. Let's go with that. That was DeMar Stepp's reasoning, and he passed that on to Michael Davis, and we find ourselves here today. And everything I've heard from the Attorney General is let's stay with that. Let's ignore the recantations, and let's stay with that reasoning of a 12 and a 14-year-old. Reasoning that they now reject as men.
And also, they just
We
didn't
heard
like him.
testimony from Dr.
Mhm.
Franklin, and she spoke in detail about the science supporting the improbability of the ID that DeMar
Yeah.
Stepp and Michael Davis
I didn't see anyone, but
all
that was him.
patients. And why were they convincing? Well, we heard that he was throwing out facts that defied all logic. He construed that as something else. He construed that as the impact of a trauma, fear, being scared.
Felix,
What he didn't realize,
come here.
because they were effective liars,
That's your first 20 minutes, but you can proceed.
what he didn't realize, Your Honor, is that it was a completely fabricated story. Now, if we go to the next slide, we have the testimony of Scott Roeder. And that testimony just provides some visualization for the court in terms of what things were like that night. And you've got someone whose whole intent in being out at 12 o'clock at night, planning to commit a homicide, their whole point is not to be seen. And that's what he's depicting here. As DeMar Stepp said that evening when he was first interviewed, this assailant came out from around 5609, the house next door, and started shooting, making an ID nearly impossible. If DeMar Stepp had really
Hi,
seen
Christy.
all he said that he saw,
How you doing today?
he
Hope
wouldn't
you're
be
good.
here
Hope you're
today.
doing well.
He wouldn't have survived that shooting. He would have been staring someone who was intent on killing him right in the face for 3 minutes. It makes no sense.
Yeah.
And then, Your Honor,
Hello.
we have the testimony of
Hello.
Nicole Bailey,
Hello.
which was incredibly credible. She places herself on the phone with Christopher Dunn. during a
Incredibly
time
credible.
When
Yeah.
cell phones were not prevalent, and he was at home on his landline. That testimony is corroborated by the testimony of Mr. Dunn's mother and his sister. And we know, Your Honor, from the testimony of Detective Stidham, if we go to slide 29, we know that that alibi was never thoroughly investigated. Had it been investigated thoroughly, had it been submitted to trial, we might not find ourselves here today. Slide 30, we have the testimony of Christopher Dunn from the habeas hearing, where he points out that he provided the alibi testimony to his attorney, but it was never presented. The final analysis, Your Honor, if we go to slide 32, we have met the standard as laid out in the statute. Our case parallels Amrine almost exactly. In light of the resulting lack of any remaining evidence of M. Ryan's guilt from the first trial, M. Ryan has already met the clear and convincing evidence standard. For our confidence in the outcome of the first trial was sufficiently undermined by the recantation of all of the key witnesses against him. And that's what we have here, Your Honor. There is no evidence that remains. The recantations are credible, and we have met our standard of clear and convincing evidence of actual innocence because there remains no evidence upon which a reasonable jury could return a verdict of guilty. And in fact, Your Honor, in this case, there simply remains no evidence at all. Thank you.
Thank you, Mr. Gore. You'll have about 6 minutes on rebuttal, give or take.
Mean girl, mean girl. I don't understand how they can continue when the entire trial was based on those two testimonies and they've been recanted.
That's what I don't get about her. Does she believe it, or is it just a job?
Yeah, exactly. Like, why go to this much trouble and then some?
Like, is she being forced? That's her boss. You've got to go try this. You need to win it. Doesn't matter. All costs. I don't get it. And if she's
You're
okay
fine.
with
You
that,
can move the
there's
podium
something wrong
over
with
if you
her.
need to.
Yeah. Or is it another notch in the belt?
Yeah.
Because that's that gentleman there is the St. Louis Circuit attorney, and the gentleman behind her is the appellate attorney. So she's going up against,
Big
the big
people.
guy.
Yep.
Yeah, is it a notch in her belt?
I mean, if she can say, "Oh, I won against,"
Yeah.
look who I won
From the court.
against.
You may proceed.
Counsel. An innocent man's best defense is the truth. The evidence and information that has been presented to this court and that is available to this court to review post-hearing is written with lies. And those lies come from Christopher Dunn. I'd like to start first by talking about the alibi evidence that has been presented to this court. Whenever Christopher Dunn, the first time that he spoke to anyone about his whereabouts on the night and early morning.
Right, now I'll just explain this. The night that the incident happened, he was supposed to be at a halfway house because I think he'd just actually been released from jail for some other smaller thing. And so he was supposed to be at this halfway house, and he had gone to his mother's place, and he was on the phone to his friend at the time. So his mother and his sister and the friend that he was on the phone to from 11 o'clock to 1 o'clock all had covered his, like, had his alibi, basically.
Yeah,
But
they lied.
when the police turned up to question and find out where Christopher was, the mother lied and said he wasn't there because he was supposed to be at the halfway house.
Yep.
They didn't know at the time that he was a suspect in this case. So that's what makes this look dodgy. That's why.
Yeah. I mean, they were lying because they were scared he was going to get in trouble. They didn't
Yeah.
realize, like, oh my
No,
gosh, they
no.
would have never lied about that.
Probably thought the police were thinking, oh, he's not at the halfway house. Is he here?
Is he here? Yeah.
Yep. So,
Makes sense.
yep.
Gabby.
Of May 18th, May 19th, 1990. He told law enforcement that he left his house at 10 p.m. He rode around the city with his friend Wilford Rickman. He said that he was then around midnight, after he was with Wilford Rickman for a couple of hours, around midnight, he went to the residence of a friend named Terry's house and spent the night, returning to his house at approximately 7 a.m. the next morning. This statement was given to the police before Christopher Dunn had the opportunity to talk to his family. The first time that his mother, Martha Dunn, spoke to the police, she told the police that at the time they had arrived at her house, which we heard from Detective Stidham today, that it was sometime after 2 o'clock in the morning. That at the time they arrived there, Christopher Dunn had been home about an hour and a half prior, and he was with two other individuals and left. The second time that the police talked to Miss Dunn, she said that he had not entered the premises since they had been to her house before. But upon learning what he was arrested in, the clothing that he was arrested in, she said, well, he must have come home because he's in different clothing than he was the last time I saw him. She said, the last time I saw him, he was in a white t-shirt, white shorts, and a blue baseball cap. The third time that the police spoke to Martha Dunn, she stated that Christopher Dunn left her residence between 11 and 11:30 during the evening of May 18th, 1990. And that he came home around 2 a.m. And that at that time, he entered the family room, started taking off his clothes, and went to sleep on the couch. We heard testimony read into the record from Chris Dunn's family a couple of years later at his PCR hearing. This story completely changed. Now, Chris Dunn is purporting to have been home all night. But what we also know, and what we heard today, is that whenever police arrived to Martha Dunn's home, where Chris Dunn is purporting to have been on the night and the murder of Rico Rogers, and when police got there, Miss Dunn let them into their home to look for Christopher Dunn. And they went to his room, and he was not there. They did not see him in the home. And that is because the purported alibi of Christopher Dunn being home all night is a lie. We also heard alibi evidence, well, from this PCR hearing. And this is in the record. And his attorney, the trial attorney, Janice Good, was asked why she did not present certain alibi evidence. And she answered part of it was that it was a very weak alibi, if not a bad one. And she testified that she then had a conversation right before trial with Angela and Wilford Rickman, who had been present during the interview with Mrs. Dunn and all the other people. And the record will give context to that it was the rest of the family members. And they indicated, in fact, Christopher had left the house at some point and that he was actually gone at the time of the shooting. Nicole Bailey is another piece of the purported alibi today of Christopher Dunn. We heard today that Nicole Bailey, then Nicole Williams, at some point, I think she testified today that at some point she spoke to Emily Blood, which the record will show was the PCR attorney representing Christopher Dunn. And she testified, and I think I showed her that testimony on cross-examination, that she came down and spoke to Ms. Blood and told her everything that she was testifying to at the habeas hearing, and agreed with me that it was everything she was testifying to today. She knew that her friend, Christopher Dunn, had been at that point convicted of murder. And so she was providing information to his attorney to try and help him.
Oh, wow.
And she didn't appear at that PCR hearing. And so this offer of proof was made by Emily Blood, the attorney. And she said that Nicole Bailey told her that she got a phone call. And it turns out that it was Christopher Dunn trying to get a hold of her and talk to her. And they chatted about, she accepted the phone call, and she chatted about the birth of the baby and so on. When I questioned her about the timing of the reception of that phone call, she seemed somewhat unsure and offered that maybe it was after the Hunter program was over because she had also watched Hunter that night. And that's about as pinned down as I could get her on the timing of that phone call. That's the extent, and the judge says, of the offer of proof, and she continues. So that's the extent, the length of the phone call. She estimated to be what she called a short phone call, and then she estimated it to be 5 to 10 minutes in length. And we heard that she told Ms. Blood everything that she testified to in court, but that's not true either. Because in 1993, at the time of the PCR hearing, this was what she remembered, that she had a short phone call with him at some point, couldn't really pin down the time, and it was a short phone call. And we know from the statement that Miss Dunn gave to the police before Christopher Dunn had an opportunity to talk to his family and coordinate his alibi, Miss Dunn said he was home around 11:30, and then he left and came back at 2 a.m. So it's very possible that Nicole Bailey did talk to Christopher Dunn at home that night, but that she is not correct and does not recall what time that was. We heard Miss Bailey testify today that she doesn't have a memory of being on any medications. And we talked to her about those medications. She indicated, well, I wasn't on any that would affect my memory. We saw that she was on a regular regimen of medication 24 hours after giving birth to a baby. It's fair that just like she didn't remember those medications, she wouldn't remember the specifics of this phone call. So now let's talk about the eyewitness testimony that has been presented to this court.
There is no eyewitnesses.
I'm going to back up. The allegations from the circuit attorney in their motion to vacate is that these recanting eyewitnesses lied and that they had a motive to lie. The evidence shows that these boys had absolutely no time to fabricate any sort of identification. And there's a lot of allegations about throughout the record about police coercion, about the police pressuring them, saying that Dunn was someone they wanted to get off the streets. He was causing a lot of problems for them, talking about how the police were showing them pictures of their dead friends, telling them, you have to make this right. And there is absolutely no evidence of that other than those claims.
Doesn't mean it didn't
We heard
happen.
from the lead detective today, as well as the lead prosecutor on the case, that said they just followed the evidence and that these were two witnesses who were consistent and cooperative throughout. So let's look at those statements. So Michael Davis, we heard this today. Michael Davis first identifies Christopher Dunn as the shooter to Rico Rogers' brother. And we talked about this a little bit yesterday, but Rico Rogers was on the porch of Marlon Tolliver, which is on the same street he lives on. So, you know, we can assume that Michael Davis runs down the street just a few houses down and then lets Jerwai Rogers know Christopher Dunn shot your brother.
Speculation
And
right
this is
there.
immediately after the crime happens. And then Michael Davis gives a statement to the police. We heard about that today.
She didn't have
He said that
anything.
the shooting happened,
No.
that he saw his friend fall to the ground, that he instinctively decided to fall next to him and play dead. He never said that his instinct was to run away and take cover. This 12-year-old boy's instinct was to play dead and to fall down. And that's what he did. And he could see as he was falling and looking that the shooter was Christopher Dunn.
Sure.
And then Michael Davis came and testified in front of the jury. And this is just one part of the transcript from that jury trial where he identifies Christopher Dunn as the
comedian
shooter.
lady.
But he tells the jury, and do you see the person in the courtroom
I
who
said
fired
it.
those shots? Yes, sir. Who was that?
Said it with a
Christopher.
straight face.
I'm sorry,
Yep.
Christopher. Okay, the defendant, Christopher Dunn? Yes, sir. And excuse me, then we have Demoris Stepp. So Demoris Stepp identifies Christopher Dunn as the shooter immediately. Not only is that supported in the record in the police reports, but that's also supported by testimony from Eugene Wilson, who also says that right away he was saying, and I think we looked at his testimony from his habeas hearing, it was Christopher Dunn or Christopher Dunn shooting at us. So again, prior to the police ever arriving on scene, Demoris Stepp, running away from the shooting, meets up with his friends Marlon Tolliver and Eugene Wilson, who are in the 5500 block, walking west towards the Chinaman. And he tells them Christopher Dunn is shooting. Along with Eugene Wilson is this individual, Derry D. And he talks to the police and says the same thing. Right after the shots were fired, they meet up with Demoris Stepp, who is fleeing the bullets, and Demoris Stepp says that Christopher Dunn is shooting at them. And then we have Demoris Stepp's first statement to the police. So we heard today that initial officers arrive on scene, start securing the scene before homicide detectives can get there. And whenever they do, they make contact with Demoris Stepp and Michael Davis. And Demoris Stepp said that they observed Christopher Dunn as the individual who had done the shooting. Then Demoris Stepp is also interviewed by the detective. And you heard about that statement today. And he told the detective what he saw, told him that he was sitting on a porch with his friends, that he heard a gunshot, that he looked over, he saw Christopher Dunn firing a weapon, and then he looked away, heard a second shot, and ran. And that he ran towards the 5500 block of Labadee, where he then met up with his friends and told them what was going on. This portion of Demoris Stepp's statement was talked about a lot today when he said, I looked at his face, but you know how you see somebody and you don't see him, I thought my mind, was playing games and I looked dead in his face. And Judge, we cannot assume or interpret what Demoris Stepp meant by that. We've heard a couple different interpretations of that. But the reality is that he said that he looked this individual dead in the face and he identified him as Christopher Dunn. And then Demoris Stepp told the jury, and again, this is just a part of that transcript where at trial where he identifies him a couple of times. But when he's asked, all right, and as you three were there, what happened? He said, I looked around on the side of the gangway where the two gangways were, and I seen Mr. Christopher Dunn. Then he proceeds to talk about what happened and how Christopher Dunn was the shooter. It's important to note that prior to or up until the jury trial,
Morning, Kim.
these two boys were incredibly consistent
Good
in
morning,
their
Kim.
identification. and in their recounting, I believe that there was some argument
to
that
see you
their
as
statements to police were
always.
inconsistent. But inconsistent is contrary to. I believe what we heard is that Demora Stepp identified Christopher Dunn as wearing a white t-shirt and a blue baseball cap. And that Michael Davis identified Christopher Dunn as wearing a white t-shirt and sunglasses. I submit to this court that those are not inconsistent. So it's just two individuals focusing and seeing different details. The testimony was not that one individual placed him in a blue shirt or a black hat. An individual didn't say that he was wearing a different color hat. It was just different items of clothing, and that's reasonable. No two people experience anything the same, and that's just common sense.
Elf liar.
So these
Elf
two
liar.
inconsistencies begin.
Elf liar.
This is where the inconsistency helped him write this affidavit. It was his version of the event. So essentially, we have this recantation from Demora Stepp, where he used
I
his
love hands of power.
and the court will see that in all of the submitted evidence or admitted evidence and information available to the court. But Tony Kelly fills out an affidavit, and in his affidavit, he says there were 4 people. And that explains why Demora Stepp puts 4 people as the shooter and also places Tony Kelly there, because this is the story, the cultivation of the story beginning. Demora Stepp was interviewed in 2017. And even then, it's very different than what he put in that affidavit, because that story didn't work. That one didn't match up with the rest of the testimony and with the rest of the evidence that had already been presented in this case. And so that story was abandoned. And then in 2017, Demora Stepp said that he saw Christopher Dunn there. And at this point, he said that there was another individual there with Christopher Dunn. And he doesn't know which one the shooter was. But unless Christopher Dunn has a clone walking around, he saw him.
He's making it up as he goes along.
I want to talk a little bit about the evidence that was presented by the circuit attorney with Eugene Wilson. Eugene Wilson testified that he was walking up, approaching the porch of where this shooting occurred. Nobody else puts him there. Every other statement that is available to this court to consider is that Eugene Wilson was walking to the Chinaman restaurant,
That was a big one.
was walking towards it, and was not near the house at the time of the shooting. The 2018 testimony from Demora Stepp in the habeas hearing, he says there's no way that Eugene Wilson could have seen what happened because he was not there. Eugene Wilson cannot say what Davis saw. He cannot say what Stepp saw. And he told this court that he was guessing or assuming. He also talked and has talked over time, the couple of times that he's provided statements about this case, about how it was dark, there were street lights, but no lights coming from the house or on the porch. And yesterday he showed this court where those street lights were in 1990. He marked them on the demonstrative exhibit used by the circuit attorney, and we had another look at them today with Dr. Franklin. Even if this court finds that he is being truthful about where he was located at the time of the shooting, which I submit to you is not credible in light of all the other evidence, his testimony is still consistent with the witnesses on the porch, Demora Stepp and Michael Davis, being able to see the shooter. He said that he and the other boys had been outside all night and evening. Common sense is that their eyes have adjusted to the dark. He said that he was within talking distance of the boys on the porch. And he agreed with me that the boys on the porch would also have been within talking distance of the shooter. He testified here in court that it was light enough for him to see the faces on the boy of the porch. And he also said that the muzzle flash would have allowed him to see Dunn because he was light-skinned. What this tells us is that it was also light enough for the boys on the porch to see the face of the shooter. They were also within talking distance of the shooter, and there was enough light for someone within talking distance of someone else, according to Eugene Wilson, to see that individual's face. Also, there's already enough light to see their faces, but the muzzle flash of the gun would provide additional light, and he agreed with me that it would have provided additional light and enough light for people on the porch to see the shooter being in a white shirt, which Demora Stepp and Michael Davis both reported the shooter to be into law enforcement. Eugene Wilson's testimony also gives interesting additional information to the way this shooting happened. Now, for the first time this week, court heard evidence of some potential alternative motive. Now, the state never had to prove motive in this case, and the state has no burden here today. But it's convenient now that there's an alternative motive with zero corroboration of the incident for which they claim some sort of retaliation is being taken. Eugene Wilson testified that Christopher Dunn was not friends with Demora Stepp or Michael Davis. Christopher Dunn had been friends with Marlon Tolliver and Eugene Wilson since they were young children, though. Wilson testified that he knows Christopher Dunn would never shoot at him or pig Marlon Tolliver. but he agreed that Dunn did not have the same level or type of loyalty to Stepp or Davis. So the evidence is that Demora Stepp saw Christopher Dunn in the gangway before the shooting started. And Wilson agreed with me that all of the shooting was going towards the porch. He was not shot at and never felt any bullets fly by him. And the court heard from Mr. Roeder that the only ballistic damage at the scene was to a gutter on the porch and to the victim's head. And so I would submit to this court that Christopher Dunn was seen in the gangway as testified to by Demora Stepp, and perhaps longer than Stepp saw him there, but hiding in wait and saw his close friends that he has that loyalty to leave. And once they were no longer on the porch, he shot at the two people that he doesn't have loyalty to and did not shoot at his longtime friends.
And to me,
Judge,
he's not
although we don't have to-
light-skinned.
No, no. No.
I mean, I would not say he is light-skinned, but I guess I don't get to make that call. So I will stop talking now.
prove motive, and the state never had to prove motive. There is a motive here, and that is the evidence that this court heard about the gang affiliation or the gang perpetration going on in the Wells Goodfellow neighborhood at that time. And I'm going to go through this pretty quickly, but the eyewitnesses told the police, or Demora Stepp told the police, that the boys in the neighborhood started calling themselves Bloods, and that Christopher Dunn had started identifying as a Crip. We also have that sworn statement from Eugene Wilson, where he happens to initial right next to the paragraph where it said Chris Dunn had recently been incarcerated.
El-Raz.
And whenever he was locked up, the neighbor.
El-Raz.
El-Raz.
El-Razzmatazz.
Got your gifted membership. Thank you.
Giddy up.
Giddy up, El-Raz. Enjoy. And make sure you go over to the Defense Rest page and thank Jody.
And click that like. You know you
And
want it.
subscribe.
You know
It's
you
free.
want it.
Doesn't
Yeah.
hurt.
No.
Won't
Nope.
doesn't
no
hurt.
shame.
There's no pain in it.
Nope. Yep. And you won't get spammed either.
No. Nope.
Yep.
neighborhood started turning blood, and
Join
he
the
was
fam.
affiliated with the Crips in jail.
Yes. Do it.
We know that
Aw.
Rico Rogers was wearing a red hat
Aw.
and red tennis shoes at the
Thank
time
you,
he was shot
Regina.
at. And we know that Christopher Dunn
We
was wearing
tried.
a blue hat.
Yay.
Gang violence and gun violence don't make sense. And it doesn't have to make sense. But gang violence and gun violence are typically senseless crimes. And I submit to you that even though we don't know what the motive is, and it might not have been that, we don't have to know. But it certainly tracks. Your Honor, you heard testimony about those eyewitness identifications, and Dr. Franklin testified about how familiar face recognition can be automatic and rapid. How a familiar face can typically be recognized in a fraction of a second. The record and evidence shows that the defendant, or that Christopher Dunn, was familiar to these boys, and the circumstances exist and are credible and are supportive of them having correct and accurate identifications. And a jury thought so too. The real question regarding motive,
Did they? They
did
did
these
42
boys have
minutes.
any motive to lie?
The jury took 42 minutes, yes.
Yeah. So did they consider anything? 42 minutes.
That's justice in a nutshell, isn't it?
I mean, like, at least pretend. Get lunch.
Mhm. So she's only got a couple more minutes left, I think, and then there's a quick rebuttal, and that's the end of this hearing. But just stay tuned because that's not the end of the story.
Nope.
And they
Not even
didn't,
close.
and they didn't have time to. The first ID
In fact,
and
this has just been a warm up.
Yeah.
every ID subsequent to it, up through the trial, came whenever this 14-year-old boy was under stress of a dangerous event, similar to an excited utterance, something that courts find declarants are more reliable when making those excited utterance under the circumstances and stress of those events. Something that Judge Omer said whenever he was testifying stood out to me. And he said, you can't just rely on what's put down on paper. You have to talk to the witnesses. You have to get a feel for them. You can't just read the police report. So I have to make my own determination. This court will never hear and hasn't heard from the two witnesses that have allegedly recanted their identifications.
Why not?
Why
Yeah.
not?
But some people have. Detective Sidham interviewed them. Judge Omer heard them testify at grand jury. Judge Omer heard them testify at trial. He said that their testimony was strong and that they were cooperative throughout the way and throughout the life of the case, and a jury agreed.
Of course I will.
An innocent man's best defense is the truth, and you've just heard lies from Christopher Dunn. And he's never told you where he was that night.
Yes, he has.
If the court has doubts as to the truthfulness or reliability of the evidence offered in this hearing, then I submit to you that that evidence is not clear. And if the court is not instantly persuaded that Christopher Dunn is actually innocent, then I submit to this court that it is not convincing.
You're not
34 years
convincing.
ago, Rico Rogers' murderer was convicted by a jury of 12 people in the city of St. Louis. That verdict was accurate, and that verdict should stand. Thank you.
Thank you, Ms. Eastep. Are you doing the rebuttal? Okay.
I will, Your
He
Honor.
said, but
He was looking at her like,
Mm.
I could do you next.
You may proceed.
Thank you, Your Honor, and may it please the court and counsel. Judge,
I like this attorney.
fantastic, incredible explanations for these two boys' lies, unsupported by any evidence whatsoever, does not matter. Their failure, the Attorney General's failure to even mention the controlling Supreme Court precedent here, speaks louder than anything that they've said to you today. After all is said and done, Judge, at the end of the day, the bottom line is this simple fact. No credible evidence of guilt remains. And that fact alone ends the discussion. As it was in Amrine versus Roper, so it is in the case of Christopher Dunn. There is no physical evidence linking Christopher to the crime. Instead, he was convicted solely on the basis of recanted testimony. And whether they lied at trial or lied when they recanted and recanted again and again does not matter. The fact remained that this conviction is solely based on the testimony
Good
of
morning,
proven
Lydia.
liars unworthy of
Morning,
trial.
Yeah.
do to have.
And therefore, no
You can
credible
make an
evidence
like that
remains to
any
support
time.
this conviction. The Supreme Court told us in Amrine versus Cooper at pages 548 and 549
This
specifically,
went for the good.
held that under these rare circumstances, there is clear
Wow.
and convincing evidence of actual innocence. And as such, confidence in this conviction is so undermined that it cannot stand and must be set aside. Judge, these rare circumstances present the court with a rare opportunity. Based upon these facts, the absence of credible evidence before you, and the clearly stated law of the state of Missouri. The circuit attorney refiled this matter only after a thorough and independent investigation. Now we implore you, Judge, to do what Judge Hickle could not do 4 years ago. Grant our motion and finally set aside the conviction of Christopher Dunn. That's all.
Thank you, Mr. Shaw. Thank you, everybody. I know we've already entered an order, I think, that sets forth the post-trial briefing schedule, correct?
I don't know if it's been written down. I think it just was stated on.
Hickle.
Hickle.
An H.
Okay. Yeah, if we haven't done that, we will do that. So you can do a memo that says case submitted, and whatever those dates you previously said are fine with me. I want to thank both sides for your zealous advocacy in this matter. And, I think our system is set up to be adversarial, and I'm not sure that was contemplated when this proceeding or in these types of proceedings, but I do find it valuable that we have the Attorney General here cross-examining and adding to the evidence. Although it does make my job a little harder, I think. So I think that's all I have to say. I think I have plenty of work to do. You guys are all welcome back here anytime, but please don't come back very soon because I have a lot of stuff to do right now. So thanks, everybody. We'll be adjourned for today.
All right, so that's where that ends there.
I have that huge binder that I need to go through. And Judge Hickle, that was in 2020. He was the Texas County Circuit Court judge. He declared then that there was no reasonable jury would have ever convicted him
Mhm.
on the evidence that was presented. However, there was a law in place at the time that barred Christopher Dunn from bringing this to appeal this in front of him because he wasn't on state unaliving row. So he had to, he couldn't do anything about it. It's like, I don't think anybody would find you guilty, but I can't let you go. The law doesn't allow it. They finally changed that law. And so that's why he was finally able to just now bring this appeal, and they were finally able to go forward with it. So, I mean, that in itself is horrible that he just like, well, sorry, I can't do anything about it. Good morning, Kelly. How are you?
Morning, Kelly. All right. So let's get to the next one. I had them in order. Okay, so this is the decision of this judge.
And this is this a news thing?
It's a 20-second, just quick, and then
So
I'm going next.
Just so you guys know, it wasn't like when we did Lamar Johnson, when they came back and had everybody back in court and the judge delivered his decision. This judge either didn't, I don't think he did that. I think he just
No
like
footage I could find.
sent it to the attorneys. Here's the decision. I don't think he brought anybody back to court. So we don't have that.
No.
So we just have the news.
Correct. So I'm just sort of playing it in chronological order of the next lot of events because, yeah.
Yeah,
You'll
so pay
see.
attention. There's a lot.
Yes, yes. And I'll explain as we go.
Her face says it all.
And for more than 3 decades for murder, a life sentence that even a judge now says you would not be found guilty of today. That's a reality for Christopher Dunn, and the state of Missouri says he must stay behind bars. Now, he and his family fear he may never walk free. If you're confused by this, so are we. And that's exactly why, after learning of Mr. Dunn's story, we traveled to the prison where he is now serving out his life sentence to hear his story directly from him.
Here we go. This is a free call from an offender at the South Central Correctional Center. Hey, babe. Hey there, babe.
Hey, Chris.
For 32 years, this has been Christopher Dunn's lifeline. A maximum of 15 minutes. That's all he's allowed for each call. But Dunn savors every precious second, a momentary distraction from his life sentence behind bars.
Missouri called themselves the Show Me State. They showed me nothing except that they refused to admit their wrongs. You can't have hope in the justice system. Hope died a long time ago.
Dunn was just 18 when he was arrested for a murder he is adamant he did not commit. Now, at 50 years old, after surviving 3 heart attacks and being stabbed by an inmate, he's not sure what will run out first, his patience or his time.
Are you concerned that you might die before being able to be vindicated?
To be honest with you, yeah. I fear that the truth of what happened to me may never be known.
In the early morning of May 19th, 1990, a 15-year-old boy named Rico Rogers was fatally shot on the front steps of a friend's house in St. Louis, not far from Dunn's family home.
Was there any point where you said, are you responsible for the shooting or?
I know he wasn't because we all was at the house. And I told the police that. And he said, well, family people lie for family people.
According to Dunn's mother,
Does that bring back memories?
Oh, it brings back lots of memories for him. I would have been his partner. I don't know why. I just thought, like, I mean, he's as a young preteen, teenager, whatever I was. Yeah, I would have been Fred Dyer's partner.
I'm waiting for a comment from Udahef.
I
The
want
family
to
had
see.
sat down to watch the crime drama Hunter, and
I was a junior in high school.
Chris was on the phone with his friend Nicole Bailey, who had just checked into a hospital to give birth.
Police come search the house. But it was kind of weird because how can he shoot someone if he's at home?
Two neighborhood kids, 14-year-old Demoris Stepp and 12-year-old
Thanks,
Michael
Kelly.
Davis, testified under oath that Chris was at the scene of the crime. The jury
That's a long time
deliberated
ago.
for less than 45 minutes, and at 19 years old, Dunn was sentenced to life in prison plus 90 years.
Reports suggest he didn't have a good public defender.
I thought she had Chris' best interest in heart.
Now, have a listen to how long this public defender interviewed Christopher before she represented him at trial.
Oh,
But she didn't do anything. I read the transcript after. I could have done better than that.
He had so many alibi witnesses that were never called to court.
In 1999, Kira Kaywood, a volunteer for a nonprofit magazine called Justice Denied, was assigned to write an article about Dunn's story. Over time, she was ultimately convinced of two things: that he was innocent and that she loved him.
I have no hope in the system, but I still believe in love, though. You find
How
something that
amazing
you
is
like.
that? She was a reporter to report on his story early on when he was convicted, and they got married, and she's waited over 30 years for him.
which is crazy. So
Yeah.
yeah, good for
Just-
her.
Wow.
Like Kelly
just
said,
You better grab
love
hold
is
to it.
love.
Absolutely. If there's anything good come out of this, it's that.
Yep.
If not, it's going to get away. It might be gone forever.
8 years ago, they got married in a tiny ceremony at the prison. As he awaits his happily ever after, which may never come, he clings to his first love, pencil and ash to paper,
Aw,
bringing
good.
his family
Good,
and
isn't it?
friends all to life right beside him.
Wow.
A lot of people say that they're innocent
Yes.
when they're really guilty.
Yes.
So what stood out to you about Chris that you believed him?
I reviewed the police interviews of the witnesses versus what they said in court. It didn't line up.
In 2012, Keir hired Dan Grothaus, a private investigator, to uncover what Dunn's Missouri State Public Defender never did: prove absolute innocence.
Michael Davis testified. We needed his testimony to be recanted, and he did without any problem.
Did we see Dunn do it? No, nobody seen Dunn do it. Back in them days, them streets was dark. You ain't got no lights in the streets.
Is there anything in your mind that has changed with your statement or with your version of events?
Still the same thing. I didn't see nothing.
Armed with Davis's recantation, along with new witness testimony, Dunn's team was able to file for post-conviction relief to vacate his conviction in 2018, which they all thought would be an open and shut case.
One turned to the other one, and I heard it with my own ears. He said, should we call the institution, tell them to get his stuff?
So that was 6 years ago. They recanted their statements. He's been proven innocent, and he's still there.
Ready to go?
One of the guys came out and he told Mom that he believed Chris was innocent.
He said, Mrs. Dunn, on behalf of the state of Missouri, I am so sorry for what's happened to your son. Remember that, Mama?
Was that day harder in some ways because you
Yeah.
really thought
Yes.
justice was going to be done?
I had his clothes and we had the car and we were just ready to go have something to eat afterwards. And yeah, it felt so close. And when we all had to walk out of there without him, it was heartbreaking.
Mrs. Dunn, you've been really strong this whole time, and I'm curious what aspect made you break down just now.
It's just hard. I'm tired.
Judge William Hickel took 2 years to render his decision, in which he wrote, coupled with evidence in the record that petitioner had an alibi, this court does not believe that any jury would now convict Christopher Dunn under these facts.
Now, here's the kicker.
And 2
But
years.
despite that belief, Dunn cannot walk free because of a 2016 ruling in the Missouri state case Lincoln versus.
He cannot be released because there is a precedent, because the appellate court can only overrule the decision if the claim of innocence was made on a capital punishment case. And Christopher was convicted to life plus 90, not the death penalty.
Cassidy, which limits releases for freestanding claims of actual innocence to capital punishment cases.
And you would have been better off had you been given a death sentence than
Right
life
there.
plus 90 years.
Ronnie Lincoln's case is holding me from being free. The judge said I was innocent. Your circuit judge in Missouri said I was innocent. Kimberly Gardner, the circuit attorney for the city of St. Louis, says that I'm innocent. Why can't you free me?
Kevin Strickland, another man sentenced to life, spent 43 years in Missouri prisons for a wrongful conviction.
What does justice look like?
That's a tough one. I mean, I don't.
One of the Missouri Three?
I think so.
And Lamar Johnson?
Lamar Johnson, I think he is the other one.
Yeah. This links them all sort of together.
Yeah.
It's a good little tie-up.
No, I haven't seen it yet.
He was only able to be released last year thanks to Senate Bill 53, a new law that gives prosecutors an avenue to free innocent prisoners. The bill was inspired.
So it says there that a prosecuting or circuit attorney in the jurisdiction in which a person was convicted of the offence may file a motion to vacate or set aside the judgment, which is who Chris has representing him. He has the circuit attorney, which was the gentleman in the blue suit. So it's only because this new bill was created that they were actually able to fight this case.
Inspired by a man at the center of another wrongful conviction case in Missouri, Lamar Johnson.
Oh, I could talk about Lamar Johnson for months, weeks, days.
Kidding.
Lamar Johnson has spent 28 years in prison for a crime he also says he did not commit. The sole witness in the case has recanted his statement, and the actual killers have admitted to the crime. And yet he too remains locked away because of his life sentence.
I want to say that Mr. Lamar Johnson was the one that paved the way for everybody to create a mechanism. So I know that a lot of individuals want to know, are we taking our due diligence and time to pursue these cases, because this is the last line of defense for justice.
Dunn, Strickland, and Johnson make up what Chris has dubbed the Missouri Three.
You feel that if this had happened to you in another state, you wouldn't still be behind bars? You feel this is specific to Missouri?
I would like to think that I believe that if I was in Illinois, if I was in California, any other state, Kansas, yes.
Thanks to Senate Bill 53, St. Louis prosecutor Kimberly Gardner has the power to request Johnson's and Dunn's release, starting a process that ends with the Attorney General.
We have an Attorney General in this state that believes that finality
pretty much finishes that one. 1 second. I did skip one video, so hang on. It's a 20-second video, and it.
That is true, Adair. But fortunately, there is more evidence against some people than others, and these guys just didn't have it. And the witnesses all came back and said, nope, I made it up. I lied. Or the police gave me a deal, or the police, I was scared because I had my own stuff going on. There's so many things in these cases, but there are people in prison. Yes, they do say they're innocent, but they're like, it's like, oh, your DNA was all over the place.
Mm-hmm.
They didn't have DNA back then, and these people were not exonerated by DNA. So things have changed. And I think we're going to see more and more of these people come up.
Yep.
For these hearings.
The Innocent Project got involved with Christopher Dunn's case. That's one of the reasons my mouse is, I think I need a new battery, but okay. So this is the verdict that Judge Strickland from this in May from the conviction hearing.
Now to some breaking news. A judge has vacated Christopher Dunn's murder conviction. Dunn served more than 30 years in prison for killing Rico Rogers in 1990. His case was based on testimony from eyewitnesses who both state and defense attorneys now call unreliable. The judge says Dunn should be immediately released from custody. Our top story.
That was the judge's ruling.
Now to some.
Although it does make my job a little.
Now to some breaking news.
Just keeps going back to replay. Stupid thing.
Twilight Zone.
Yeah. All right. So then we saw the video of. Oh Lord! It jumped a heap of them. Okay. So then the judge says, yes, you can get out, but then the Attorney General files an emergency motion to dismiss based on this Missouri law. And this is what happens.
Our top story. He was just minutes away from walking through.
I was gonna say they filed the appeal, emergency appeal with the I think the Missouri Supreme Court to stop this judge's decision.
Yes.
So.
Yes.
Which is insane to me, but I guess it's not out of the ordinary.
So this is what came of that.
Free. The 11th hour move by the Missouri Supreme Court, halting the release of Christopher Dunn.
I was hoping that there was going to be an end to this obstructionist nonsense.
Just hours ago, Christopher Dunn thought after serving 34 years, he'd walk out of prison a free man. Good evening, I'm Kelly Jackson.
And I'm Mike Bush. A St. Louis judge ordered Dunn to be released from prison this afternoon, 2 days after his murder conviction was overturned. Robert Townsend is live outside the courthouse with reaction to a legal roller coaster for Dunn and his family.
Mike Kira Dunn left this courthouse hoping to hear that her husband would be free from jail. But again, Dunn tells me tonight she's devastated because it never happened. Just minutes after a St. Louis judge ordered Christopher Dunn to be released from a Missouri prison after spending 34 years behind bars, Dunn's wife was ecstatic.
We couldn't be more happy and amazed and thankful.
What's the first thing you're going to do when you see him?
Cry and just put my face in his shirt.
Christopher Dunn was just 18 when he was convicted of killing a 15-year-old in North St. Louis in 1990. Dunn has always said he was innocent. Monday, a judge overturned his conviction. Wednesday afternoon, an emergency meeting was held after Missouri Attorney General Andrew Bailey filed a motion to keep Dunn behind bars. Judge Jason Sangheiser then ordered Dunn to be released from a prison in Licking, Missouri.
I was hoping there was going to be an end to this obstructionism.
Okay, so they said, yes, you're innocent, you can go. Then the Attorney General said, no, you can stay. And then...
yeah, he was literally signing the papers to be released from jail when the ruling came down that said, nope. They said no, he cannot be released.
Nope. So
I can't imagine what that felt like.
So the circuit, because of the new law in that I can't remember the name of it that I showed you before, but it allows the circuit court attorney to argue against this statute that the Attorney General used to stop his release. So then they fought for that, and I've forgotten which one I've played now. I'll put this.
Calling from a correctional facility and may be monitored and recorded.
Like, prison is a living hell. Every day you get to go through something totally different. Well, after being stabbed once in prison, I had a 3 heart attacks. After having a few dizzy spells and fallouts, prison for me has been a living hell.
For more than 30 years, Christopher Dunn has maintained his innocence while locked away in a Missouri prison. For just as long, there have been plenty of efforts to free Dunn. But despite a mountain of evidence in his favor and a judge saying evidence of guilt is lacking, it is an uphill struggle. So how did Christopher Dunn get here? On the night of May 18, 1990, a teenager named Rico Rogers was shot to death while sitting on a porch in Dunn's neighborhood. Chris says he was home when the shooting happened, on the phone with a friend who was giving birth at a nearby hospital. Chris says he had no motive to kill Rico, since he wasn't even familiar with the victim.
Never knew him at all. I never knew his family at all.
Wow.
All I knew is that his family moved into my neighborhood.
The next day, police arrested the then 18-year-old Dunn. He was tried and convicted on the testimony of 2 young boys, ages 12 and 14 at the time, who claimed Dunn shot at them while sitting on the porch around midnight.
His public defender spent maybe a total of 20 minutes with him before she represented him at trial. He was convicted in 45 minutes of jury deliberation. And that was it. I mean, he was an 18-year-old. He was given life without parole plus 90 years. He was initially offered 10 to plead out. And he said, no way. I didn't do this. I don't want these people to think I did this. I don't want these parents to think I took their child from them. I would never do that. Refused it, and they really threw the book at him.
Both boys later admitted to lying on Dunn because they didn't like him and officially recanted their stories. Neither boy actually saw who pulled the trigger because it was dark. No physical evidence ever linked Dunn to the shooting. In 1991, Dunn was sentenced to life without parole plus 90 years.
It was a 2-day trial with jury selection. So really it was opening, witness statement, witness testimony, closing, 1 day. Really, it was a 1-day trial.
Hi, Teresia. Hello.
Welcome.
Yes, it is messed up. We're nearly there. We're nearly there, though. People, like it's better to get a year or two, something there. Yes. Yeah, but they offered him the 10-year deal and he said no. And yeah.
Sorry, the pause at you.
Yeah, it's a good one, isn't it? Yeah. I'm gonna have to snip tool that. Hang on.
Sorry.
That's a great picture. That'll be that's gonna be good for a short. There you go, right there. Oh dear.
Yeah, Regina, I agree. Oh, bye, Udav. Have a great meeting. They're so fun, aren't they?
Bye, Udav.
Yeah, they pleaded for 10 and they won't let them out after 32. Okay, somebody can't do math. Like, it's insane.
Yep.
Insane.
And it still gets done. He explains it really well, actually.
And unfortunately, it's an all too familiar reality for poor, especially Black men in this country. It's quite astounding.
What's a typical day like for you?
Prison is a constantly battlefield. There's like landmines everywhere. You don't know where to walk. You're walking on eggshells in prison. But you have to stand up, but you have to wait until the kitchen is almost empty before you can sit down and eat comfortably. You always have to watch your back in prison. Make sure nobody tries to stab you in the neck or hit you in your gut. You can set someone off just by simple gaze. You know, you got to be comfortable with what you're doing, what you say, how you look, how you present yourself to them.
Kira Dunn initially met Christopher back in 1990.
This pretty much repeats itself. So they have another. I couldn't find any other footage on judgments or hearings or verdicts, but eventually.
A St. Louis man who spent 34 years in prison for a crime he says he didn't commit could be just minutes away from freedom. Thanks for joining us. I'm Mike Bush.
And I'm Ann Allred. Christopher Dunn's conviction was overturned earlier this week.
but an appeal kept him behind bars. Hours ago, a St. Louis judge ordered Dunn to be released from a state prison. 5 on your sides, Robert Townsend was at today's hearing. He joins us live from downtown St. Louis. Robert.
Hey, and right now, Kira Dunn tells me her husband is still in the process of being released from that state prison. And as you can imagine, she's saying she cannot wait to get her hands finally on her husband. Take a look at the background. Again, Christopher Dunn was just 18 years old when he was convicted of killing a 15-year-old in North St. Louis in 1990. Dunn has always said he was innocent. He spent 34 years behind bars. Monday, you'll remember a judge overturned Dunn's conviction. Today's emergency meeting was held after the Missouri Attorney General filed a motion to keep Dunn behind bars. But after about 20 minutes, Judge Jason Sangheiser ordered the now 52-year-old Dunn to be released from a state prison in Licking, Missouri within the hour. Dunn's elated wife of 10 years left the courthouse telling me her prayers have finally been answered.
I'm ecstatic. I've had an initial breakdown. I've gotten it together. I'm just so thankful to the judge for not just seeing the truth and doing what was it, what the most we could have ever hoped for was him to do that and rule accordingly to make sure that Chris obtains his rightful freedom, that this wrongful conviction stops here. 34 years is enough.
Again, Kira Dunn tells me she's just getting to that state prison, and she says she is just minutes away from seeing her free husband. We'll have much more tonight at 10. Live downtown, Robert.
All right, let's go to the good bit. So, he's proven innocent in May. The conviction was overruled. The Attorney General emergency appeal said no, can't leave. Then it was overruled again by Judge Strickland, which now, that was 2 days later. I think it took 2 days after the.
I think that's what they said. Yeah, 2 days later.
Reversed that and said let him go within the hour. So, yay! But wait, there's more.
Yeah,
Christopher
but I
Dunn is
agree with
opening up a
Tracy.
life he
Tracy, I
lost after serving
saying
30.
her name right, but her comment: if he had done this somewhere throughout all those years being in prison, he would have let it slip.
Yeah,
he would have told somebody. He's never changed his story, no matter what that woman said.
No. Nope. Okay.
4 years behind bars for a crime he did not commit.
Dunn was just freed last night, and now tonight he is sitting down for a powerful interview with Fox 2's Max Dieknight. And Max, Dunn says he still can't believe he's a free man.
Yeah, Mandy, surely that's right. He says it's surreal. He obviously missed out on a lot during his time behind bars, but after more than 12,000 days in prison, we met up with him for his very first day as a free man. After more than 3 decades, Christopher Dunn walked out of the Carnahan courthouse a free man Tuesday night. Wednesday, he sat down with us.
There's no words that you can describe exactly how I felt.
Dunn described embracing his elderly mother, who he says he was hardly able to see during his time behind bars, and he credits his support system, especially his wife Kira, for his release.
They give me a purpose. They give me a reason to live. Before Kira came into my life, I was hopeless.
Dunn is starting a free life from scratch. He says he feels like he time traveled. After all, things have changed a lot since 1990.
Now they got this Xbox thing and a whole bunch of the cell phone. When I left, they had a brick.
The 52-year-old says he's enjoying his newfound freedom. And while money is a concern, Missouri only compensates for convictions overturned by DNA.
He said that in 1991, that cell phone thing was a brick.
Yeah. Yeah.
It was.
The evidence, he says that is not stealing his joy.
Most people are focused on the financial aspects of it. Me.
Okay. So the reason they're saying that is because he is not entitled to any compensation for this because his conviction was not overturned by DNA evidence.
Which is crap.
So basically, They've just told him that the last 34 years of his life are worth nada. Not a dime. Nothing. And look how stoic this man is.
I may not be here 5 to 10 years down the line because of my medical problems. So I'm just trying to focus on what I can see in front of me.
Dunn says he's accepted that the people who wrongfully put him behind bars for the 1990 murder of 15-year-old Rico Rogers will never be held accountable. He's at peace with that.
I've learned that in order to let go of the hate, the bitterness, the anger, the frustration, you have to cut yourself from any ties to any tethers that's holding you back.
Dunn says he has one last thing he wants to share with people like you who hear his story.
Give those who are incarcerated a chance to be heard. Don't turn your backs on them, because this can be your son, your daughter, your niece or nephew, your cousin or auntie. Don't ever say that it can't happen to you, because it can.
There you go.
And I
that's
say that all the time. When I see like these things happening to people that are not right, they're not right. Freaking Alec Baldwin. I would have when that all started, I was like, you did horrible things. Then when I saw the evidence, I'm like, oh no. And then I didn't even care about the evidence because they didn't turn everything over. So right then and there, it's like, it's not about him anymore. It's about what they did to prosecute him and what they didn't do. And that can happen to any of us. Any of us.
Everyone deserves the right to a fair trial. Now, my
Yes.
question to you is the presumption of innocence. So you are innocent until proven guilty beyond a reasonable doubt. But what if you're found guilty and then proven to be innocent? What happens then? You have to wait for how many years?
Absolutely. That's the other thing. People are like, well, they can just appeal it. Okay. 34 years. 34 years. And changing a law so you could do it.
Yep. Because he wasn't allowed to even apply for that because he wasn't a death row penalty case.
Yeah. I mean, it's
Yes.
insane. So,
Too
and yes, I've heard of that. I've used it.
Yes, I tried it. Doesn't work.
And only like 10%, I think I saw where only like 10% of appeals are even heard anyway. So you're not even guaranteed that. And it's really, really hard to get a judge to overturn a jury verdict. They don't want to undermine the jury.
Yep.
So this whole, well, they can just appeal. Well, yeah, they'll appeal it. So what? You don't want to have to appeal. You want the best trial first time. That's why I always say at the beginning of every trial we watch, just be clean. Both sides. Just be clean. That's all we need. And there are good prosecutors out there, and there are clean prosecutors out there. There are great defense attorneys out there. We've seen them. But then we've seen some pull some crap that you're like, why are you doing this?
Yep. I don't know whether it's because I was talking to AJ before the stream about this. You know, I think that perhaps the presumption of innocence may well be starting to fade, you know, innocent until proven guilty, especially because you've got all of this this social media presence. I mean, and people once you start getting some traction and some popularity, everybody has an opinion. Everybody. And what weight does that pay? What gravity does that have on public opinion? And, you know, jurors may not have heard evidence about this case, but they've watched social media, they've had opinions, and they're sitting there. I don't know. I don't think a lot of them sit in that chair and actually recant to themselves, innocent till proven guilty, innocent till proven guilty.
I'm not sure. I've heard a lot of attorneys talk about that jurors take it very They take jury
Oh,
duty
absolutely.
very seriously. I've heard jurors talk about that. I think the fact that that YouTube, streamers, whether it's people like us who are not attorneys, we're just watching from a layperson's point of view. We're not telling you like legally what's happening. We're just looking at it going, oh my gosh, why is this happening? But it gives the other side, because the media and the state gets their narrative, and the state gets to put their narrative out there, and the defendant cannot speak. They have to remain quiet. They have to remain silent, because everything you say can and will be used against you. So you're not allowed to present your case, and it can take years to get you to trial. The whole time the media is out there and the state's out there just blah, 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 and you are whatever they want to make you out to be. So now you've got to fight that. But I think being able to view these trials on YouTube and be able to stream these trials, I think has brought a lot of transparency to these courtrooms, and it is exposing a lot of stuff, and they don't like it.
No.
So,
but are they? Is that then, like you've got these, we were just saying before, why is this woman prosecuting when there is no evidence? Maybe it's fame.
I don't know.
On YouTube.
Like I said, is it just a job for her? Is it just the next step up? Because if you don't believe, like, I would have a hard time sitting there going, wow, there's no evidence, put him back in prison forever.
Mm-hmm.
I couldn't do it. I couldn't do it. But that's me. If she doesn't have a conscience, that's on her. And, yeah. And I'll tell you, I've not paid attention to that one, Kim.
Oh, I watched it incessantly at the start, but yeah.
Because I want to be able to view it and then just see the evidence. I want to be that unbiased juror. So I have just I've cut all of that off. I've not paid any attention. Like when it goes to trial, I'll be there if they let us. And it will all be new to me. So I'll see what the jury sees. And that way, that's my whole point. I want everybody here to see what the jury sees. You only get to go on by what's presented in court. It doesn't matter what's not presented in court. If it's not presented in court, it doesn't exist. I don't care what the news says. I don't care what anybody says. It's like
But Dunn's wife said there were so many witnesses that weren't allowed to testify on his behalf, and that could have set him free. It could have turned the case.
So the Delphi case is a mess.
Mm-hmm.
That judge is a mess. She is showing every day that she cannot be trusted, and and this poor guy. I do not think they have the right guy. I've never thought from the beginning they had the right, because he just doesn't. There's so many things that doesn't line up in Delphi. Richard Allen.
I haven't followed that one, but I have.
I don't follow it a lot. But I see the headlines because it's news here, and that judge has just done so many shady things, as has the prosecutors, and the prosecutors are fighting to keep the cameras out of court, and she's agreeing. So why? I get it. Defense doesn't want cameras in court, but prosecutors, you should be proud of your case. Bring it, and let the defense put on whatever defense they want. If it's so out there, who cares?
The prosecutors are there to present the facts, unbiased, factual evidence. There you go. You make your decision, jurors. You are the deciders of fact.
Yep.
No bias.
Yep. And Tracy, I can't say the defendant can't speak while they're waiting to go to trial. While they're waiting, they can't speak and get their facts out, because it can be used against them. Yep. They're just really not allowed to speak. But the prosecutors, they can put whatever out there. So it's really frustrating. I do have to go soon, but yeah, I could go on and on and on. I won't.
You just have to watch Law and like if you watch the trial on Law and Crime and you look at the chat.
Oh gosh.
I rest my case.
Yep.
So, yeah.
Well, I've just listened to the commentators or whatever on court TV. one of them said, if you're innocent, you have a bench trial. If you're guilty, you have a jury trial. I'm like, that's how you determine it? Really? That's the dumbest thing I've ever heard. And she's like, oh, the courties know that. I'm like, you are what is wrong with the system, lady. You are what is wrong. Everybody's guilty in your eyes.
Yep.
And it's just so frustrating. Like, some people are clearly guilty. Like I said to Adair, I'm sorry, there's just the evidence is all there. And then you have stuff like this that you have to think, and heaven forbid we think anymore.
Yeah. And this poor guy's, 34 years he's had to pay for it. And now it's almost like, this is one of the reasons we chose to do this, because of these issues. But they're coming up more and more now, like with Karen Reid,
It's that exposure.
It's this constant, it's like they have to prove their innocence instead of
Oh,
the other
absolutely.
way around.
The prosecutors burden shift all the time and never get called out on it.
Yeah.
And it's so frustrating.
Yeah. So there you go. That was the climax of the.
Yesterday was pretty boring. I'll be honest with you. Then we twisted and turned, and
yeah, we got there in the end. But it was important to lay the foundation of
the
injustice, basically.
And Missouri is trying to change the law so that these people can be compensated. But how much is your life?
Yeah,
giving up all the best years of your life worth? And I thought, okay, let's say they give you $10 million. But let's say they give you $10 million and you can't leave it to anybody. Who cares?
Oh, whilst I remember, I did find this online on the Innocence Project, I think. So they actually have set up a justice fund if anyone wanted to donate to that.
Yes, I did see that. I meant to say that they had set up a GoFundMe for his life outside of prison. Last update I had, which I'm not sure how long ago that was, it had raised over $11,000. And I know that's a lot of money, but that's not a lot of money.
So you can just scan that QR code with your smartphone and it will take you directly to that GoFundMe site if you want to donate to his cause. So there you go.
Thank you.
All right. Welcome. Da, 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 da. We need a drum roll for the end.
That's it.
The conclusion. All right. Well, I hope you enjoyed that. Something to think about for sure. And I'm going to ask myself every trial we do now at the very start, presumption of innocence, and approach it a little bit differently, I think. And yeah, get a different stance.
I try to approach it as I listen to what the prosecutor has to say. If they sway me, okay, they've swayed me with their evidence. But then I listen to what the defense attorneys have to say. And if they sway me back, they've either swayed me to not guilty or they've swayed me to reasonable doubt. But if they swayed me at all, prosecution loses.
Yep. If you think for 1% that there isn't, you're not convinced, it's reasonable doubt. 1% is enough. 1% is enough. Now, AJ, I think you're having tomorrow night off, and Monday is a holiday for you guys, so it's a long weekend. I think I might scramble something up for tomorrow. So put your notification bells to all, so that if I do pop up with the live stream,
Adair, we do have we have one starting the 16th, so we're going to kind of just keep our stuff short until that one starts.
We've got a few lined up, a few little ones just to fill in the gaps before the next big one. So yes, we do. Which
and that one will be interesting. So you should be around here for that one, Adair, because it's going to be interesting, I think.
So yes, that one will start next Wednesday, because you're not available Tuesday, are you?
The one I'm talking about, Carly Gregg, starts the 16th.
Oh yes, it does. Yes. There's a couple.
But
There's a
we
couple
have,
before there, but
yeah, but we can,
I will,
that's our next big trial, Dare, is
yes.
Carly Gregg. She
Yeah.
starts the 16th. We've got some fill-in ones that
Mhm.
aren't live. I know you hate that, Adair. But to fill in before we get to Carly Gregg, that one's going to be interesting. So, alrighty, I got to take off. So
Okay.
let's rock
So
and
you're
roll
not
out of
back
here.
on Wednesday, is that correct?
Wednesday, I will be back.
Yep, no worries. And stay tuned. I will definitely be tomorrow, and probably Monday. And I'll take Tuesday from Monday. So, thank you for being here.
Yes, thank you,
have
everyone.
yourselves a lovely Thursday, and I will put my Jimmy Jams on and toddle off to bed. So thanks for being here. Hope we've rattled your brains a little bit, and
A little.
I'll see you all tomorrow.
I'll see you later.
Adios, amigos.
Dee and Debbie here, fill your screen with cheer. Hit like and tap subscribe, join our